Imagine waking up one morning and the gun you legally bought, the one sitting in your drawer, is suddenly at the center of a Supreme Court battle that could flip everything you thought you knew about federal law. That is not a hypothetical. That is happening right now, and the ripple effects are coming straight to Canada whether you realize it or not. Stay with me, because this one is big. What is going on, everybody? Welcome back to Credit Smart Canada. I'm so glad you're here today because we are covering something that most Canadian financial and legal channels are completely sleeping on. The United States Supreme Court is in the middle of a landmark gun rights case that has the potential to reshape federal authority in ways that go far beyond just firearms. And if you think that has nothing to do with your life up here in Canada, I need you to keep watching, because cross-border legal shifts have a funny way of making their way north faster than people expect. So let's break this down in plain language, no legal jargon, no political spin, just facts and what they actually mean for regular people. The case at the heart of this whole showdown involves a federal law in the United States that bans people under domestic violence restraining orders from possessing firearms. Now on the surface, most people hear that and think, okay, that sounds reasonable. But here is where it gets complicated. The Supreme Court, after its massive Bruin decision back in 2022, essentially changed the entire legal test for evaluating gun laws. They said that for a firearm regulation to be constitutional, the government has to prove it is deeply rooted in the historical tradition of firearm regulation going back to the founding era of America. Not just that it is a good idea. Not just that it solves a modern problem. It has to have a historical twin from the 1700s or 1800s. And that, right there, is where the federal government is sweating. The defendant in this case, a man named Zaki Rahimi, had a restraining order against him and was found with guns. Federal prosecutors charged him under that law. His lawyers argued the law was unconstitutional under the new Bruin standard. The Fifth Circuit Court of Appeals agreed with him. That sent shockwaves through Washington because if that ruling stands, it does not just affect one man. It means the entire framework of using federal law to restrict gun ownership for domestic abusers could be struck down. And then the dominoes start falling on other federal gun restrictions too. Now the Supreme Court heard arguments and the justices were visibly wrestling with this. Even conservative justices who pushed for the Bruin standard seemed uncomfortable with where their own logic was leading. Justice Amy Coney Barrett literally said out loud in oral arguments that she was struggling with how to apply this historical tradition test to a modern domestic violence law, because obviously in the 1700s, domestic violence was not even recognized as a legal category the way it is today. Women had almost no legal rights. So how do you find a historical twin for something that society did not acknowledge back then? That is the trap the court set for itself, and now they have to figure out how to get out of it without blowing up decades of federal gun law in the process. Here is why this matters to you if you are watching from Canada. We are talking about the legitimacy of federal authority to regulate firearms at a national level. Canada has had its own battles on this exact question. The long gun registry debate, provincial pushback on federal firearms legislation, the ongoing tension between Ottawa and provinces like Alberta and Saskatchewan over gun rules. These are not isolated Canadian arguments. They are part of a broader continental conversation about how much power the federal government should have over individual gun rights, and American court decisions have historically influenced how Canadian legal scholars and politicians frame these debates on our side of the border. Beyond the constitutional theory, there is a very practical concern here. If the U.S. Supreme Court rules in a way that weakens federal gun oversight, you are going to see an increase in legal and illegal firearms crossing into Canada. We already have a significant problem with guns flowing north across the border. A ruling that limits the federal government's ability to track, restrict, or confiscate weapons from people with violent histories makes that problem worse. And that is a public safety issue that hits Canadian communities directly. On top of that, at Credit Smart Canada, we always look at the financial angle because that is what helps you make real decisions. Gun manufacturers and related industries are watching this case like hawks. If federal restrictions get rolled back, you are going to see shifts in how certain U.S. defense and manufacturing stocks perform. Canadian investors with exposure to American markets, ETFs, mutual funds, cross-border portfolios, need to be paying attention to what happens when this ruling drops, expected before the end of the court's term in June. There is also the insurance angle, which almost nobody talks about. American homeowners and renters insurance, liability coverage, all of it gets repriced when the legal landscape around firearms shifts. And because Canadian insurance companies model their actuarial risk off international data, including American trends, what happens south of the border does not stay south of the border. The Supreme Court is expected to rule before the summer recess. Most legal analysts believe they will find a narrow way to uphold the domestic violence restriction while still technically preserving the Bruin framework, essentially kicking the harder questions down the road. But a few justices have signaled they might go broader. And if they do, it will not just be a gun ruling. It will be a statement about the limits of federal power that reverberates across every policy domain: financial regulation, environmental law, healthcare, you name it. This is the kind of moment where paying attention early puts you ahead of 95% of people who will scramble to understand it after the headline drops. And that is exactly why we talk about these things here at Credit Smart Canada, because being financially and legally aware is not just about your credit score or your mortgage rate. It is about understanding the forces shaping the world your money lives in. If you found this breakdown valuable, do me a favor and hit that like button right now. It genuinely helps more Canadians find this content when they need it most. Subscribe to Credit Smart Canada if you are not already part of the family, because we drop videos like this regularly, connecting the dots between big legal and political events and what they actually mean for your wallet and your life. Drop a comment below and tell me what you think about this case. Do you think the Supreme Court will uphold the law or blow it up? I read every single comment and I want to hear where you stand. I will see you in the next one. Stay smart, stay sharp, Canada.